The Bankruptcy and Insolvency Code 2016. On 28th of May 2016, with the signing of the President of India, the Bankruptcy and Insolvency Code 2016 became finally passed by the Parliamentary System in India. However, majority of the provisions came to force in between 5th to 19th of August 2016. With these provisions coming into force and them being invoked in the high-profile Kingfisher Airlines case, the code gained prominence. However, before moving on with the details of the code and its implications on the Indian economy, I would like to discuss the significance of the issue from the point of civil services examination. Significance. In the wake of the recent incidents such as the Kingfisher loan default and others, and the increased non-performing assets boggling the banking industry in India, the significance of the issue in the economy, especially in the process of increasing ease of doing business in India, can be easily understood. This is also the significance of the issue in the wake of syllabus of civil services examination. By the way, before going any further, let us first try to understand the provisions of the code as has been passed by the Parliament. The code. Assented on 28th of May by the President of India, the code seeks to address the following issues along with the creation of the following specified mechanisms to address the issue. The code applies to companies, limited liability partnerships, partnership firms, other corporate persons and individuals, and any other body specified by the government. Where any corporate debtor commits a default in payment of debt, insolvency resolution process under the code can be initiated by a financial creditor, either by itself or jointly with other financial creditor, an operational creditor, or by the corporate debtor itself, by filing an application in the National Company Law Tribunal or NCLT. A default for this purpose includes a default in respect to a financial debt owed not only to the applicant financial creditor but to any other financial creditor of the corporate debtor. The code distinguishes between a financial creditor and an operational creditor and lays down different procedures for initiating the proceedings. Financial creditor is a creditor to whom a financial debt is owed and includes anyone to whom such debt is assigned or transferred. Operational creditor is one to whom an operational debt is owed, that is, debt in respect of goods or services including employment, or debt arising under any law in force for the time being and payable to the central government or state government or local authorities. The financial creditor has to move an application before the NCLT showing them the proof of default and proposing an interim IP. The NCLT will then ascertain the existence of default from the records of an IU, that is, information utilities, or on the basis of other evidence furnished by the creditor. However, in the case of an operational creditor, the operational creditor has to first serve a demand notice along with the proof of default, giving the debtor 10 days to respond to dispute the claim. If the claim remains undisputed, then the operational creditor can file an application before the adjudicating authority. The resolution process will be conducted by licensed insolvency professionals. These insolvency professionals will be members of insolvency professional agencies. Insolvency professional agencies will also furnish performance bonds equal to the assets of a company under insolvency resolution. Information utilities will be established to collect, collate, and disseminate financial information to facilitate insolvency resolution. The National Company Law Tribunal will adjudicate insolvency resolution for companies. The Debt Recovery Tribunal will adjudicate insolvency resolution for individuals. The Insolvency and Bankruptcy Board of India will be set up to regulate functioning of the IPs, IPAs, and IUs. Time-bound insolvency resolution will require establishment of several new entities. Also, given the pendency and disposal rate of DRTs, their current capacity may be inadequate to take up the additional role. The IPs regulated by the board will be created for regulating the functioning of IPs. This approach of having regulated entities further regulate professionals may be contrary to the current practice of regulating licensed professionals. Further, requiring a high value of performance bond may deter the formation of IPs. The code provides an order of priority to distribute assets during liquidation. However, it is unclear why secured creditors will receive their entire outstanding amount rather than up to their collateral value. Unsecured creditors have priority over trade creditors, and government dues will be paid after unsecured creditors. The code provides for creation of multiple IUs. However, it does not specify that full information about a company will be accessible through a single query from any IU. This may lead to financial information being scattered across these IUs. The code creates an insolvency and bankruptcy fund. However, it does not specify the manner in which the fund will be used. The code creates time-bound processes for insolvency resolution of companies and individuals. This process will be completed within 180 days. If insolvency cannot be resolved, the assets of the borrower may be sold to repay creditors. Significance in terms of economy. The Bankruptcy Code has provisions to address cross-border insolvency through bilateral agreements with other countries. It also proposes shorter, aggressive time frames for every step in insolvency process, right from filing a bankruptcy application to the time available for filing claims and appeals in the debt recovery tribunals, national company law tribunals, and courts. Bankruptcy applications will now have to be filed within 3 months. Earlier it was 6 months. To protect workers' interests, the Code has provisions to ensure that the money due to workers and employees from the Provident Fund, the Pension Fund, and the Gratuity Fund shouldn't be included in the estate of bankrupt company or individual. Further, workers' salary for up to 24 months will get first priority in case of liquidation of assets of a company, ahead of secured creditors. There are also provisions that disqualify anyone declared bankrupt from holding public office, thereby ensuring that politicians and government officials cannot hold any public office if declared bankrupt. However, the new bankruptcy law isn't a magic wand. The benefit following in are expected after 3 to 5 years from now. By the way, analysts say the main challenge will be creating a large pool of insolvency professionals who will help with the fast implementation of the law. The new regulators will also need to draft procedural rule for insolvency professionals and information utilities, among others. As has been mentioned above, currently it takes an average of 4.3 years to resolve insolvency in India, and the recovery rate of debt is very low compared with other countries. India also ranks 136th in the world's resolving insolvency ranking. This is below China, which ranks 55 and where it takes 1.7 years to resolve insolvency. The new law introduces a time limit on the bankruptcy process. In the case of a default, the time limit is 180 days, within which the resolution has to be completed. This can be extended by another 90 days by the adjudicator depending on the process. Analysts say the new time frame will help India improve its World Bank insolvency ranking. By the way, the code is not beyond controversies or criticisms. Now let us look into the criticisms that are being labeled against it. Criticisms. The government has brought in this code largely modeled on the US bankruptcy law with the good intention of facilitating timely resolution of corporate bankruptcy. However, a critical reading of the legislation reveals that unless necessary changes are made to it, the legislative intent would largely remain unfulfilled. Number 1. Issues with financial creditors and operational creditors. Under the code, where a corporate debtor fails to pay a debt that is due, the corporate insolvency resolution process may be initiated by a financial creditor or by an operational creditor or by the corporate debtor itself. Here, let us define who they are. A. A financial creditor is a creditor to whom a financial debt is owed by the corporate debtor. B. An operational creditor is a creditor who has provided goods or services to the corporate debtor, including employees, central or state governments. When a corporate debtor fails to pay a debt due to an operational creditor, such an operational creditor can demand payment of the same if the corporate debtor fails to pay the amount due within 10 days of the demand or fails to dispute the debt. The operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process. A dispute regarding the debt would be one where there is a record of a suit or arbitration proceedings having been filed before a demand for payment is made. Here lies the difficulty. To file a suit is expensive. Therefore, corporate debtors would dispute an operational debt by merely filing an arbitral reference regarding the dispute, which is also arbitration proceedings in the law, without really intending to pursue actual arbitration for resolving the dispute. Since the adjudicating authority does not have the statutory power to examine whether the dispute regarding the debt is a bona fide dispute or not, as is the case under the US law, most of the operational creditors would be left high and dry after being thus disabled from pursuing an insolvency resolution process. Even if the arbitration award is given resolving the dispute, The corporate debtor would seek to set aside the award in the High Court, which may take a long time to reach final resolution. Thus, the code does not make much sense for the operational creditor. One of the ways of remedying the situation is to empower the adjudicating authority to finally determine whether the dispute is bona fide or not, and to say that such a determination of a question of fact and hence not appealable. As far as financial creditors are concerned, they can straight away approach the adjudicating authority for an insolvency resolution process, even if there are certain disputes regarding the financial debt. This would cause great harm to business and industry, as in the case of an operational creditor, a financial creditor's application should not be admitted unless there is a determination by the adjudicating authority that the financial debt is subject to a bona fide dispute. Insolvency resolution. The insolvency resolution professional has to submit an insolvency resolution plan within 180 days to 270 days, and if insolvency professional fails to do so, or if the insolvency resolution plan is rejected by the adjudicating authority, the adjudicating authority has no option but to order liquidation of the corporate debtor. Before ordering the liquidation of the corporate debtor, it is not clear whether the corporate debtor can be heard by the adjudicating authority for granting any relief. This has to be clearly laid down. However, in spite of the above-mentioned deficiencies, the code provides a better environment for the newly emerging business initiatives in India and may prove to be a game changer, which is already visible in India's improved ranking at 130th place in the ranking list for ease of doing business. Thank you.